Hello, hello, hello. How is everybody doing tonight? I hope everybody's doing well. You can't see me right now. I'm showing you guys what I've been working on, and I'm wanting your comments and your thoughts and your opinions and your input. I have here the entire Title IX, Chapter 41 RCWs. There's a very small bit of it that doesn't pertain strictly to firearms. But this is what we're going to be doing. So I'm going to give a couple more minutes for some more viewers to join us. Hello, guys. How are you? You guys doing good? Okay. So I have here what I'm looking at right now, and what you guys are looking at is the title. All right, this is the title section. On an initiative, the title section contains what the content of the initiative will cover. All right. Make sure you guys are giving me your comments. I can see your comments on my computer screen, and I can see them on my phone at the same time. So make sure that you're commenting your input, because this is not my initiative, this is ours. All of ours together. Okay? So what we have is I've made the title "An Act Related to Increasing Public Safety by Removing Excessive and Confusing Firearm Regulations that Directly Conflict with the Washington State Constitution and the United States Constitution, and Restoring in Full the Rights of Law-Abiding Citizens and Rehabilitated Offenders to Bear Arms in Defense of Self, the General Public, or Students, and to prevent or reduce the deaths of mass shootings, of violent gun crimes, rapes, domestic violence, robbery, or any other crime that would cause citizens to become victims if they are unarmed." That's the title. So I'm going to scroll down here. By the way, the software that I'm using, that I'm so excited about using, is Microsoft Office 365. And the reason that this excites me is, one, because of the enormous donation Microsoft gave to the 1639 campaign. And it gives me just one small way to use their own stuff against them. You know? The other reason I'm excited for this is because when I enrolled in school, I got this software for free through my school. So I didn't have to pay anything to Microsoft at all. So that kind of makes me happy too. So that's the title right there. And then what we're doing is we're in Microsoft Office 365, the Word program. Okay, Microsoft Word. And all of our editing tools are up here. When you're writing an initiative, any new content needs to be underlined and labeled as a new section. All right? And the title of that new section. So like this one is the intent section. Gun violence is far too common in Washington State and across the country, particularly gun violence where the victims are law-abiding citizens who, if they had been armed, could have stopped the violence quickly without excessive loss of life or injury to other citizens. The regulations on law-abiding citizens regarding firearms in the state of Washington are causing those who follow the laws to become more vulnerable to violent crimes due to being unable to afford the necessary permits or obtain a firearm at all because of old and outdated regulations. The people find and declare, in accordance with Article 1, Section 24 of the Constitution of this state and Amendment 2 of the Constitution of the United States of America, that it is critical that these regulations be amended and repealed to restore their ability to and right to defend themselves and their children and other citizens from the unlawful acts of all those who would seek to take advantage of the aforementioned vulnerability of the citizens of Washington State. An unhindered and well-armed public can stop the acts of the unlawful, violent, and predatory criminals. All right. So now what we're going to do is we're going to click right here, and anytime you amend a section, you have to put it at the top. All right. So this section is amended to this section is amended to read as follows. All right, and these are the definitions. I haven't gone through all of the definitions and done my strikeouts yet. But you guys can feel free as I'm scrolling through here. You see something that you want stricken, you tell me, and I'll strike it out. I did add a couple of definitions at the bottom. Oh, these ones right here. Short-barreled rifle and short-barreled shotgun needs to be stricken out. I will remember that. So I will show you guys how to do a strikeout. So we're going to take our mouse and we're going to go like this. We're going to highlight it. And we're going to go up here to our editing and we're going to click. All right. And then when it's printed, the strikeouts will be there. And the printed copy is what we submit to as a bill proposal, or what we submit to what we file to get it in as a people's initiative. So we'll do short-barreled rifle and short-barreled shotgun. Okay, and then we're going to scroll down. All right, so any new content. So here we have definition number 29. Secure gun storage means any of the following: a locked box, gun safe, or other secure locked space, including the owner's own home or garage or place of business with a locked door, or any device designed to prevent theft or access to firearms by children or other unauthorized users under federal law. A hip, shoulder, or concealment holster worn close to the owner's body so as not to present would-be criminals from disarm with the opportunity to. I'll have to change that. So we go in here and we just type and then we click that and backspace, and then we click right here and backspace and add an E. Nope, we don't need to add an E. With the opportunity to disarm the owner to intentionally use the firearm in the commission of any crime, but that still allows for easy and quick access for the purpose of self-defense, protecting the public, or stopping the commission of a violent crime. C, a locked vehicle, box inside a vehicle, trunk or truck bed compartment or glove compartment that still allows easy and quick access in cases of self-defense, defense of the public, or intervention to stop a violent crime from being committed. And then I have infringe. Infringe means to limit or undermine the full intent of the U.S. and Washington State Constitution provisions regarding the citizen's right to bear arms. Impair. Impair means to limit, compromise, weaken, damage, reduce, decrease or hinder by imposing regulations that can cause a hardship on the general public when attempting to exercise their state and federally protected right to bear arms. All right. So then, you know, this is the finding of Initiative 594, blah. Okay. So, and these are just their little clauses: preemption and general repealer, short title, servability. Unlawful possession of firearms, ownership, possession by certain persons, restoration of right to possess. I haven't done a whole lot with this section. I do have a question for you guys. I want to know what you guys feel like about, well, we'll deal with that later. What do you guys feel about this section? A person, whether adult or juvenile, is guilty of the crime of unlawful possession of a firearm. How should we do that? Do we strike that whole thing, or is there just a little bit that should be stricken, or, you know, how do we do, what do we want to do with that? Give me your comments. Do we need to think about it? All right, we'll think about that for a few minutes. But down here, I did take out the after previously been involuntarily committed for mental health treatment or equivalent statutes of another jurisdiction. You know, if someone has to go into a mental health treatment facility, there's a number of reasons for it. That person could have been perfectly fine and then suddenly gone into crisis. I know a few women who have actually gone into mental health treatment facilities after their husbands requested to have them committed due to postpartum depression, extreme postpartum depression issues. So to me, that you taking away their gun rights because of a hormone imbalance, that doesn't make sense. So that's why I struck that out. Also, later on, you'll see I've also stricken out anything in reference to access to any medical or mental health records. I want to explain this one right here. If the person is free on bond or personal recognizance, here's the deal, guys. If the crime was a major crime, a serious one, or a sexual offense, a serious sexual offense, the only way that they're going to get out is on bond. Okay? The judge isn't going to release them on a personal recognizance. All right? And that's from my, you know, just from what I've seen in courtrooms when I've been in courtrooms and observing and case studies. They aren't going to release them on personal recognizance. So if a person's out on their own recognizance, the judge doesn't find them extremely dangerous. The judge finds them dangerous, they're going to make them post bond or bail. Okay? All right, now down here, I'm very concerned about what these gun restrictions do to our children. Okay? I don't understand why a kid under the age of 13 can be charged with a Class A felony and have his gun rights taken away for the rest of his life. To me, that doesn't make any sense. There's no sense in that, you know? So that's why I put in this amendment right here, except when the plea of guilty was entered by a child under the age of 13 or the plea of guilty was entered by a child over the age of 13 but under 18 who has not received a hearing to determine that actual malice was in place at the time the offense was committed, or the child who is under the age of 14 did not receive a culpability hearing in which it was demonstrated that the child felt no remorse and showed total and complete understanding of the crime the child pled guilty to. And then I struck the clause that says conviction includes a dismissal entered after a period of probation. So I took out the clause that says, yeah, you're still considered convicted and can't have your guns, even if it was dismissed after you completed your probation with no other offenses. Okay? I'm not getting very many comments, guys. All right. Also, where no record of the court's disposition of the charges can be found, there shall be a rebuttable. I struck out the word rebuttable. If the court can't find any record of the original disposition of that crime, why should it be held against you? If you're not engaging in crime anymore, and there's no original record of it, why should it be held against you and keep you from having a firearm at any time in the future? All right. I took out gross misdemeanor or misdemeanor crimes as being a reason for not being able to have a firearm. Okay. All right, and here, for the purpose of this section, intimate partner, now these are the red flag laws, or at least part of them. All right, a spouse, a domestic partner. All right, the only people that should be able to file restraining orders against you or against someone and take their firearms away are the current spouse or domestic partners or people that you're living with, because otherwise it leaves it open to, 10 years down the line, my ex-husband is going to go and file a restraining order against me, take away my gun rights, because he gets mad at me because I said something he didn't like. That's what that leaves it open to, but taking those out brings it current. All right. Permissible firearm possession for children. It shall not apply to any person under the age of 18 years who is shooting at any such location so long as a person of the age of 18 years or older is present. Hunting or trapping under the supervision of a person of the age of 18 years or older. I took out the requirement that a child has to have a license. Okay. In an area where the discharge of a firearm will not directly injure, harm, or cause unreasonable nuisance to nearby residents, is not trespassing, and the person either is at least 10 years of age or is under the supervision of a parent, guardian, or other adult approved for the purpose by the parent or guardian. And then I left the rest of the provisions in there. Okay. Possession by offenders. Now, this one I wasn't sure about. I'm still thinking on this. That's kind of why I wanted your guys' thoughts. As a sentence condition and requirement, offenders under supervision of Department of Corrections shall not own, use, or possess firearms or ammunition. All right, so that I am not sure about. I'm kind of torn on that issue. Yeah, we don't want them to have firearms, but then, you know, people who get in trouble for minor infractions will end up getting probationary sentences. You know, well, it was something small. You're not a threat. You're not a danger. So why should they have to not have their firearms? Why should they have to have their firearms taken away? But at the same time, I got to be able to word it so that violent offenders who are first-time offenders don't, like, you know, gangs, don't immediately get out and get given a slap on the wrist and go out and get their guns and go shoot people again. We don't want that either. So I got to work on that one. Restoration of possession rights. All right, so here I took out everything that had to do with being committed by a court order for mental health treatment, and this part right here is about the making a public national record of it. So they would share it with the other states, and you know, I don't like that, so I took that out. All right, I took out the entire section 3. So, oh no, I didn't. So section 3A, B, C, subsection 1, 2, 3, and 4, and D have all been taken out. This is the area that requires people who have been involuntarily committed to go back to the court and petition the court to get their gun rights back, like they're a criminal. So we're treating the mentally ill like criminals, you know? Again, I use the example of a mother who's suffering from severe postpartum depression. You know, it's not right for her to have to go through courts when she's already gone through intensive therapy to overcome this hormone-related issue. It's not right that she should have to go through the courts like a criminal to get her gun rights back. All right. So then we go down here. Subsection 3 is repealed. Subsections 1, 2, and 4 are each amended to read: all residents of the state of Washington may at any time carry their firearms in the following manner: concealed on their person, concealed in their vehicle, and openly in any place of business, openly in any public property, openly onto any elementary, middle, or high school grounds, public or private, in any state or city park. All right. And then I've stricken out A and B, and I added all firearms in section 1 may be loaded and holstered in either a shoulder, hip, or drop leg holster. B, accompanied by a magazine or revolving cylinder for the purpose of having additional ammunition if needed for self-defense or defense of others. All right, I struck out the original A, saying we can't carry loaded guns in our vehicles. I struck out the original B, calling it a crime. And I struck out the original section 3. And I struck out the state law under number 4. All right, so this is putting it back to lining up with federal law as opposed to all these horrible state regulations, because as of right now, federal law is much more lenient. I'm not happy with the federal laws either. I haven't figured out what to do exactly about that yet. All right, The entirety of section of 9.41.060 is repealed. Okay? Exceptions to restrictions on carrying firearms. There are no restrictions, so I have to repeal this entire section. All right? This section is repealed, that correctional employees are exempted from any of the firearm restrictions and the limited liability, right? All right, that means yes, they can be held liable. Yes, they are subject to the same firearm restrictions that the people are subject to. Concealed pistol license, application fee, and renewal. All right, so I'm just asking. That is, sorry, my son wants my candy. That is my chocolate, raspberry filled, breakable chocolateness goodness. No, you cannot have it.
Which one?
No.
Why?
Shoot. This section, I took out. I took out the 30 days and put in the 10 days. For the concealed carry. If the applicant does not have a valid permanent Washington driver's license or Washington state identification card, has not been a resident, it could take 60 days for them to issue it. Okay, I took that out. All right. The applicant's constitutional right to bear arms shall not be denied unless he or she is prohibited from possessing a firearm under federal law. I took out he or she is subject to a court order or injunction regarding firearms pursuant to all of that. Again, I took out personal recognizance. I took out misdemeanor. If you've been ordered to forfeit a firearm, you should have the right to get it back. All right, in a timely manner. So I took out the 1 year period and put in a 6-month period before filing an application to carry a pistol, right? All right, if you've been ordered to forfeit a firearm, it's mostly under the red flag laws, right? And those orders, unless they're made permanent, the temporary ones are heard almost immediately within 14 days. So there's no reason to wait a full year to go and get your concealed carry permit back. Right here it said the issuing authority. I scratched out authority because I don't want the state to have any issuing authority. I said, and I put in law enforcement agency. And that's checking instant criminal background checks, not the healthcare authority or with other agencies and resources. Okay. The issuing law enforcement agency shall approve a permit to anyone who is not found to be prohibited from possessing a firearm under federal law. All right. See, sometimes all you do when you're writing an initiative or trying to change laws or build a proposal, sometimes all you have to do is just change a couple of words here and there. Any person whose firearm rights have been restricted and who has been granted relief from disabilities by the Attorney General or who is exempt shall have his or her right to acquire, receive, transfer, ship, transport, carry, and possess firearms in accordance with Washington state law restored. I took out except as otherwise prohibited by this chapter because we're taking out the prohibitions anyway. A signed application for concealed pistol license shall constitute a waiver of confidentiality. Yeah, I took that little clause out. No, if they want us to release all of our medical information, we have to sign a separate waiver for that. I have to sign a separate, my 13-year-old son has to sign a separate waiver for his mother to access his mental health records. So I want the government, I want to have to sign a separate waiver for the government to access it. Although state and local laws do not differ, I took that out, and I will explain that. I really hope this doesn't make you guys mad. All right. But I was thinking about the state preemption. And yes, the other side wants it removed so that they can put their stupid little gun laws in their own counties and cities. But I'm not 100% sure that we couldn't use that, because then counties that voted down Initiative 1639 would not be forced to enact it. Right? It goes both ways. Why can't we use it as a double-edged sword against the opposition and the gun grabbers? So I'm considering striking that out, the state preemption, and just repealing it. But I want to know what you guys think about it. Robert, we're actually going to be going over some of that stuff. There's some clauses in here that were included with 594 that unfortunately, now I'm not a lawyer, but unfortunately I think they might actually affect you when they come into effect, which is scheduled to happen in July. Yeah, there was parts of 594 that hadn't even taken effect yet, and they pushed 1639 on us. But we'll get to that in just a couple of minutes, Robert. Ronnie, I will be uploading it into the Files tab at the top of our group page as soon as this live is over, and it will be posted. The link will be posted in a post as well. All right, so in here under if the applicant is not a United States citizen, the applicant must provide evidence that they have already applied for citizenship. Already applied for citizenship. I put that in as new. And Ronnie, that's exactly my thinking. I know a lot of Second Amendment supporters are against the repealing this preemption. But honestly, it goes both ways. If they repeal the preemption, or if we repeal the preemption, you know, that might be one thing that helps get gets us more signatures and votes and gets it passed. You know, that's what I was thinking. They must provide evidence that they have already applied for citizenship, meaning that all those people in that caravan we were also worked up about, they would not be allowed to come into our state and buy and get a license, a concealed carry. They wouldn't even be allowed to buy a firearm in our state. unless they're a citizen. Yes, Robert, I will. Thank you for joining us tonight. Everywhere it said the issuing authority, I changed it to law enforcement agencies. All right. Now we get to the fees. Shall be $36 plus additional charges imposed by the Federal Bureau of, we're not paying the FBI, okay? We're not paying the FBI to exercise our rights to bear arms. So I struck that out. And then here is how it was broken down. $15 paid to the state general fund, $4 paid to the agency taking fingerprints. So for every concealed pistol license, only $4 went to the police department. $4 out of 36. 15 got paid to the state general fund. $14 were, paid to the issuing authority for the purpose of enforcing. The issuing authority, that could be anybody. It could be the law enforcement agency. That's better wording. I like that better. All right, so now we have $29 out of the 36 going to the law enforcement agency. All right, same thing with the renewal fee. And then we have renewals. I haven't gone through and taken all of done any strikeouts for this section yet. Concealed pistol license, reciprocity. Yes, this one was fun. A person's license to carry a pistol in a state other than the state of Washington is authorized to carry a concealed pistol in this state if the licensing state requires mandatory fingerprint-based background checks for all persons who apply for a concealed pistol license. All right, and then I added some. This section applies to a license holder from another state who travels through this state or moves their primary residence to this state or visits this state temporarily, right? So the Attorney General shall periodically publish a list. He doesn't need to do that. That's a waste of time because we have state reciprocity. I have a hard time pronouncing that word. Concealed pistol license revocation. The license shall be revoked by the license issuing authority immediately. Oh, I need to scratch that. So we're going to highlight, scratch. And then we'll type in, first we're going to scratch those out. By the law enforcement agency. So then we're going to highlight and underline because it's new text. Okay. Immediately upon conviction of the licensee or the licensee being found not guilty by reason of insanity of an offense, I need to strike that out. How about if we just add in of a felony offense. There we go. That's better. All right. So, unless the person may lawfully possess pistol without concealed pistol license, an ineligible person whom a license was issued shall within 14 days transfer ownership. All of that's gone. This is subsection 2 is repealed. Subsection 3 is repealed. Subsection 4 is repealed. Okay, for you guys' reference, that's .075. Okay. This entire section is repealed. Delivery to ineligible persons. Dealer deliveries regulated. For you guys that have FFLs, I could use your input on this because I don't know how all these laws affect dealers because I'm not a dealer. And again, 594. Okay. 594. Some of this was 1639 too. That's where it says. Right there. See it? Oh no, that was in the legislative session. They passed that crap without us. Yep. I didn't do anything with this because it says it's only effective until January 1st, 2019. So in a couple of weeks, it's not going to be in effect anymore. And then they have this little section right here. But again, it's in regards to dealers. The waiver of confidentiality section, giving them authorization to check into our mental health status just by signing an application for a firearm is repealed. I took that out. This one. Oh, no, this needs to be gone. I missed this earlier. So we do our strikeouts. Yep. So this entire section, strikeout. Type up here. This section is repealed. All right. Officials and agencies, immunity writ of mandibus, right? Okay, so if they give somebody who's a violent offender a firearm and that violent offender goes and kills a bunch of people, those people have no recourse. The victims' families have no recourse. Also, if somebody's firearms or concealed pistol license is wrongfully revoked, we have no recourse. We can't hold them responsible or accountable. I took that out. It's completely repealed. Forfeiture of firearms. I took most of this out. But there's a couple things in here that are necessary for safety. You know, I don't want somebody who just got done committing a mass murder being able to go back and get their gun back after they get out on bail, right? So those guns should be confiscated. But then They should be auctioned off or sold by the police to the people, to law-abiding citizens. I need to specify that in here somewhere, so that they can bring in revenue to do their jobs. It would lower the burden on taxpayers. That's my thinking anyway. I struck out section 4, which allows them to confiscate our firearms. Again, this is having to do with dealers. Dealers should be allowed to have the firearms that they're selling, regardless of if it's a pistol or if it is a semi-automatic rifle. They should be able to have possession of those without having to have separate licenses for each. That's why I struck out section 2. I'm going to strike out section 3. All right, so the license fee for firearms shall be $125. License fee for firearms other than pistols shall be $125. The license fee for ammunition. All right, so it's $125. This is what I've done for the dealers. The $125 fee covers one license for all 3 of those. You don't have to have separate licenses for those 3 categories. It's ridiculous, stupid. Okay, true record and triplicate shall be made of every pistol sold. Nope, that is section 9, section 10. It's all repealed, okay? The dealer's licenses authorized to be issued in this section are general licenses covering all sales by the licensee within the effective period of the licenses. Requirements and exemptions for sales and transfers. I haven't done much with this section yet. The sections that I haven't done much with is where I would love your guys' input. Okay. I didn't do anything with this. Out-of-state purchasing. Residents of Washington may purchase rifles and shotguns in a state other than Washington, provided that the other state follows Washington state's laws. Blah, blah, blah. Reciprocity of the states. It's gone. Repealed. Okay? Purchasing by non-residents. All right? Again, state reciprocity, right? Repealed. Record-keeping requirements. The Department of Licensing may keep copies or records of applications for concealed pistol licenses provided for in blah, blah, blah. Copies or records of applications for alien copies or records of blah, 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 the copies and records shall, no, they shall not keep any copies and records. No registration, no records. We're allowed to have our weapons. All right. Verifications of licenses and restoration. Notice to federal government. This section is repealed. All right. They aren't going to send our information to the federal government. They just need to trust us. They really need to trust us. We're the citizens. We sign their paychecks with our taxes. Department of Licensing, authority to adopt rules, reporting of violations, and authority to revoke licenses. Nope. 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 Repealed. I didn't change anything in alteration of identifying marks on the firearm, because if my firearm gets stolen and I report it stolen, if they find it, I want it back. So I don't think that our identifying marks, serial numbers, etc. should be changed. All right. All right. Possession without license conditions. That means they're not going to come in here and have exceptions to our laws that we all have to follow that they don't, so that they can have a gun. All right, so I just repealed the whole thing. Unlawful firearms. I took off short-barreled shotgun or short-barreled rifles. I left machine guns because, honestly, there's no purpose for a machine gun in today's day and age. We've got better guns, other than to collect them and show them off, but that's just my opinion. If you guys want me to strike out machine gun, let me know. Okay. And then contraband. I took off the short-barreled rifle and the short-barreled shotguns. Machine gun and felony. This section I have to go through. Air gun, they put air guns on there. Throws a deadly missile. I've been through this thing dozens and dozens of times, and I did not see a deadly missile. Aims any firearm. Yeah. Possession of a pistol by a person from 18 to 21. This section is repealed. That's the age restrictions. All right. And, some of this is applicable in federal law, but here's the deal. Marijuana is still federally illegal for recreational use. But Washington State passed it, and so did Colorado. So I don't want to hear anything about, federal law. If it works for weed, it works for this too. That's my finding on it. That's my justification. All right. Dangerous weapons, that goes into knives and all the other stuff. So I skipped over most of it. Dangerous exhibitions, this section is repealed. All right. Again, more stuff about that doesn't have to. Yeah. School facilities. I took firearm off this list. Okay? Because with mass shootings at the schools, I honestly and legitimately feel that fewer kids would have died if somebody at that school had had a concealed weapon. Way fewer kids would have died because the shooters would not have been able to go from classroom to classroom seeking out those children. State preemption. All right. For those that are still watching, I know this has been a long video, but I'm going to stop right here at state preemption for tonight. Should I strike it or do we leave it? Should I strike it or leave it, guys? What should I do? Do I strike state preemption? You know what? I'm going to strike state preemption, and we can use that thing as a double-edged sword against the gun grabbers. They want state preemption? Cool. And you know what? Even if we don't get this thing passed in its entirety, we get state preemption passed, then those of us that want guns have the rights to them. All right, so we'll go bloop, 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 bloop. Highlight, strikeout. This section is repealed. Right, so I'm going to have to go in and add a new section giving the individual counties and cities within those counties the right to put it to the vote of the people in those areas, any firearm regulations. That's what I have thus far, guys. I was hoping to get some more comments and suggestions. Robert, I will look into your question. I know I just read it earlier today, but I have had so much going through my head of this information that I'm going to have to go back and look. I don't know it right off the top of my head. I will private message you, sir. Ronnie, thank you so much for watching. Jen, thank you for watching. Everybody else, thank you for watching. What I have thus far will be posted in a file immediately following the ending of this video. It can be found at the top of the page in the files section. That's where you would go onto the swapping groups and find the rules. here you'll find this. But thank you guys for watching, and I'm thinking, I'm thinking we can have this done here soon. And then we'll have to decide if we want to break it down or if we want to, do it as an initiative to the people and as a legislative bill proposal. See if we can get a sponsor for it or three. I don't know, maybe Walsh or Representative Shea or Representative Clippert will sponsor this for us. We'll see. All right, you guys have a fantastic night, and I will be back with another live broadcast Monday.
That way.